I'd like to do three things, basically profile myself and then talk about some drivers of change and then the responses that I've seen. So in terms of myself, I've been practicing since 1983, which means I've been practicing for about 33 years, and from the very first month with a computer. And I've worked in very large law firms, medium-sized and small. In the year 2000, I established my own firm, which I wouldn't describe as a boutique, even though it's a small firm, and does IP and IT. I wouldn't describe it because business law is where it's at, and for me, IT and IP are the sizzle. And I'll explain a little bit about that later on. I was for about 10 years in the Business Law Committee of the Law Society, and I found that a very useful experience. I've been a frequent speaker at professional legal training events and even more frequent blogger since 2006, and massive user of social media. The one stat that I will often quote is that I would say that 40% of what I learn in terms of new information comes from Twitter. And that's mostly in morning bus rides and afternoon bus rides. In terms of drivers of change, I'm just going to run through very quickly. I think there's a decline in trust, which is self-evident in terms of government, in terms of news, and it's certainly in terms of professions. There's dated offerings, in my view, by lawyers, by educational institutions, and I see lawyers boxed in as deliverers of technicalities rather than using the full skill set that lawyers actually have. And that boxing in happens both at the supply side, that's the way lawyers present themselves, that's how educational institutions present lawyers as being. I see it also then at the demand side. Consumers' perceptions about what lawyers actually do tends to be typically somebody with a wig who will go to court for you. Whereas, of course, maybe 50% of that might be what lawyers do, but there are vast groups of lawyers who never put a foot in court. So that perception then means that what the consumer asks you to do tends to be about the negatives rather than about the positives. What I do that I find very exciting, in fact the most exciting thing that I do, is what I would call business model innovation, which is really taking what is known as a business model and having, with the ideal client, who unfortunately nowadays tends to be over 50 years old, with the ideal client, meaning somebody who's prepared to listen and give you instructions at length and realise that it might take 4, 5, 6 meetings before you actually go bingo. With that ideal client, you're able to create hybrid business models that I haven't even thought of. And that's actually what is changing the world. What is changing the world is people who are developing business models, be they Google, Uber, or Airbnb, that are actually outlaws of the law. They break the law, and through breaking the law and gaining consumer acceptance of what they do, they basically stymie the ability of the legislature and the courts to deal with them, and then what they do becomes the norm. So, you know, I'm an IP lawyer, I've been an IP lawyer since 1983. If somebody said to me in any of the prior decades that if an organisation scanned 30 million books from libraries, would that be a breach of copyright? I think you know what my answer would have been. Well, it's no longer a breach of copyright under US law. That phenomenon is seen in Uber, is seen in Airbnb, is seen in many other places. So a lot of my job is to think outside the law, think beyond the law, and to work with that. The difficulty, of course, is that the drivers of change also involve churn. There's enormous churn in business. There's enormous churn in customers. And one of the greatest tragedies is what I call the decline of the meeting. Meetings have been, since the caveman era, the predominant way by which we communicate. The dominant mode of communication in human history is either conversation or theatre. And that happens when human beings get together. To interpose the telephone, the letter and the email, and shortly other devices is to destroy a lot of the communication. So when I say I kind of find people over 50 the best clients, it's because they actually don't mind coming in for a meeting and saying to me things like, no, you're wrong, that's completely not what I had in mind, but I'll come back for the next meeting. Whereas a younger generation will have this tendency to think that it's a pull down, pick, and what's the price, and let's go with it. And, oh no, you didn't get it in 3 minutes, so you probably aren't the right lawyer. As it actually happens, I have a very good conversion rate in terms of younger people, but I'm describing a phenomenon that I find frustrating. So how have I responded to this? I've had to be paperless by choice because I can't maintain my command of information coming in if I'm not paperless. It's just coming in too fast, especially in the fields that I'm in, IP, IT. I mean, you know, I can't keep up. I don't know how you guys keep up. Now, the need to be practical, fast, short, actionable in your advice, of course, mean that all the old ways of delivering have had to be reformed. So, like most of you, I deliver through email a lot, which means all sorts of things in terms of using bolding, using headings, structuring things very differently. Now, another way of responding for me has been that I integrate a number of fields. It was my good fortune in the 1990s to bump into a bunch of management consultants and suddenly realise that that field explained the problems that I was having then, meaning clients would ask me to draft, for example, a contract, and I would be saying, so what's your business process, without realising that I was asking a question that came from management consultancy. Or I'd be saying, tell me about your business functions, without realising that that came from management consultancy. So I've had to gain new skills in order to cope with the boxed-in nature of being perceived as a lawyer alone, meaning somebody who's looking for specifically legal facts, whatever they may be, and then delivering them as legal solutions. Well, actually, they're integrated solutions. They're integrated with IT, with management consultancy, even with psychology. So, as I was saying to a client yesterday, 60% of the value that I deliver happens before I even draft a contract. Whether that be in business modelling or that be the psychology of the deal making. And of course, for that client, that was a new perception. Now, I think there's a number of things that the Law Society and others could be doing. I've worked for a number of years very closely with Simon Lewis, who's in the room. Simon's had a seminar for lawyers who are in the fringe, who are heavily users of information technology. And last year, or a year or two ago, he's added to the seminar that he was having annually a component which is called Cinch Launchpad, which is an opportunity for lawyers who are interested in developing apps to come and test them, come and get criticism of their own and critique others. Then in the final few seconds, I'd like to talk about what I consider to be the current status of legal tech, as it's now known, legal tech, all one word. Now, I think there are very few breakthrough approaches. We're in, if we look, there's a famous thing called a hype cycle, or the hype curve, which is by Gartner, an IT consultancy, and it's basically a curve that goes like that. We are, I believe, at the height of the hype cycle as far as AI is concerned, as far as machine learning is concerned, etc. And we're going to be coming off it. But as we come off it, there are other things that are going to come along.
Could you explain, you say...
The hype cycle?
We're at that.
We're at the peak of the hype cycle.
What do you mean by that?
What happens in the Gartner hype cycle is that early on, there are early adopters and market pushers who introduce the technology. So that's at the bottom of the curve. As they push their propaganda out, propaganda uses a positive word in the 1920 sense. As they push their propaganda, the hype begins. They place ads, and therefore newspapers cover them, and they take journos to lunch, and they get coverage. Now, then everybody starts raving about it, and you get to the peak when everybody's writing about it and saying it's the new tomorrow, but without giving you necessary examples of people who've actually adopted the technology. And so we're at that peak. So if, in my own... I'm referring currently to the things that get people involved in legal tech particularly excited, whether they be machine learning, artificial intelligence, or apps of any description. And that dreaded, horrible, cliche word which means nothing in 99% of the case, disruption. If I see that word one more time, I'm going to shoot it. So we're at that peak where that word will now disappear. There'll be another word, because that's the way the hype cycle works. But right now, there's too much talk about too little that's actually happening. And so the question, all I'm saying is there are real developments. They need to be encouraged and supported. They need to be encouraged and supported at the university law school level. Melbourne Law School had a very interesting course recently, and there's a video on YouTube you can watch, where each group of students, there was 5 groups, used Neotologic engine. Neotologic is an AI company in New York. They used that engine and they created 5 different apps to serve 5 different purposes. One of them, for example, was how to set up a not-for-profit venture, and they created an app for that, which was really a decision tree. Another venture was, how to deal with the fact that you might have been fined 50 times and then didn't want to go to court and then were embarrassed, and you then went to a local community centre and said, what do I do? Well, they'll walk you through the app. So how many universities are teaching students about app development? I think at that university level, it's already happening at primary school level and secondary, but at the university level, to get lawyers to just be good at text is crap. The skill set that lawyers need is much more than text capability. They need to be able to be graphic designers. They need to think graphically. And at that Melbourne University gig, the managing partner of Slater and Gordon, to every single one of the team members said, have you given any thought to doing a workflow in your app? And of course they hadn't, because text has been privileged. Now, so that's stuff that can be done at the university level. Then stuff at the university, stuff at the Law Society level, there's a range of things the Law Society could do that would be different. And essentially, it's about, as I said at the beginning, it's about not boxing lawyers in to being pushers of text, because then at the end of the day, we end up with decisions, as we have for the last 20 years, that are 70 pages long. It's outrageous. Who can understand all that?
Perhaps we might pause there and ask you a few questions. Could you just explain to me what technology you currently use in the way you conduct your practice?
I work on very simple technology, but I think I've been lucky to use it cleverly. So for example, nested folder structure of a operating system, whether it be Apple or Windows or whatever, I maintain a very sophisticated precedent database that I've developed over that 30-year period. So that's number one. I use browsers like everybody else does extensively, but I think the thing is with the precedent database, I probably excel in knowledge management, and so that kind of gives me the ability so that when the emails come through or the phone calls come through, I'm really navigating my knowledge database relatively quickly, if not in the call, in order to productise the deliverable. Productise meaning define what it is that I might be able to deliver, get some sense of what it might cost or how long it might take. So the technologies that I use aren't anything novel or special. I am on a path towards using machine learning in a venture that I've been working on really for about 5 years. But that's not at the stage where I have much that I could say to this committee.
Can I ask where you see the future of technology within the legal profession? How you see the profession adapting technology?
It's a very hard question. As has been said by many commentators, lawyers will always be here for necessary reasons, and so will other highly skilled people. But the ability to capture information, productise it, and have it delivered to people, that skill set to do that will become more and more in need.
Are you using technology to work smarter, more efficiently, or are there other reasons for doing it?
I think the deliverables have to be really smart. So my contracts are highly modular. They work off a common clause library. They work off common formats and layouts. I have metadata rules that I follow. So it's really just being a 21st century librarian.
Yes, I think that's the first time I've heard lawyers being described that, but I can see where you're coming from. Any other questions?
What sort of what things are stopping you? You said you've used technology to a certain extent, but you're clearly very passionate about it, and want to sound like you want to embrace it to the full extent. What barriers do you sort of come up against that?
Well, the financial resources are always limited, and it's good to have a network of lawyers that you can talk to and switch and exchange ideas with. And as I say, with people like Simon Lewis, and there's Philip Argy in the room and others, when we gather annually, we have our secret cave meetings. And that's a bit of a sort of a tester of where things are at. And I have to say, in the last 3, 4, 5 annual meetings, you can just see it exploding. Meaning things that were talked about as wouldn't it be good if people realise are now sort of like, oh, I've got an app now, can I just show you what I've got? It's like, oh, that's pretty good, you could do this to it. So the encouraging of that line of thinking and then broadening the content of the continuing professional legal education skill set. I mean, enough already with the law. We know that it's complicated. There's no way a human being... business lawyers do not know all business law. All business lawyers know that. You'll never see that in print. It's impossible to know business law. There's too much of it. And yet every problem that comes in, it's not a cute little corporation setting up problem or a cute little trademark problem. It's a myriad of things. So the skill set to manage all of this information, and it's beyond knowledge management. It's skills of, talking along the lines of what you or community has been talking about. And I think breaking out of the mould, one of the most interesting things about what this committee has been able to do is you've actually hit the social media age by filming this. You've allowed people like me and all the other speakers that I've listened to actually say what they believe. I've forgotten the name of the gentleman who's talking about litigation being broken. That is so right. You'll never see that written as clearly as he spoke it in the Law Society Journal. In other words, let's talk truth. So in other words, we are losing market share. We are losing trust in consumers. We're being a battering ram of people boxing us into a little corner. And let's stop talking about what 10% of the lawyers do. Let's stop talking about what 10% of the lawyers produce. Let's talk about what everyone, like the ones that have spoken to you, do, and let's use video more. Because then let's use podcasts more. Because then people actually say what they believe rather than self-edit and worse, self-censor so that to reflect a profession that doesn't exist anymore.
How do you think artificial intelligence will affect the legal profession?
Enormously. It's already affecting everything. 6 months ago, if you looked at what Google Photos could do, and then 6 months later last week, you've got Apple trying to catch up with its own renditions of it, it's enormous, and the pace of it is unbelievable. So it affects the way you gather photographs already. It affects the way every time you search, you're being tracked. It's artificial. Google is an artificial intelligence company from day dot. So if you use Google, you are using artificial intelligence. I use Google when I'm drafting contracts. Oh, so I'm using artificial intelligence. Yes, you are.
And are these conversations, there's a lot of passion here, is that coming from, have clients asked for that or? No,
the clients don't. The clients are not aware of the sorts of things we're talking about. The passion comes from, look, let the cat out of the bag. I never wanted to be a lawyer. I wanted to be a filmmaker. And then about 12 years into being a lawyer, I went, my God, this is really creative stuff I'm doing. But I couldn't put a name on it. And then I discovered IT in a big way in the 1990s, and as I said, management consultancy. And I suddenly went, now I understand what I'm doing with contracts. I'm actually creating businesses. And so that's where the passion's coming from, the excitement, artistic if you like, intellectual I think, excitement of what you actually do versus the frustration of people going, oh, he's just doing legal work. I'm not doing just legal work. I'm helping create your business. So when I listen to people, as I do a lot on YouTube and people in Silicon Valley, venture capitalists, etc., they speak with this passion. It's not the passion that you will see in a courtroom.
Thank you. Are there any other?
Noric, I'd like to ask you about the attitudes or the impressions that clients have as a result of this, following on from that question. And you drew what I thought was a really interesting distinction between clients over 50 and under 50. Is that a sign that the over 50s are not quite accepting the technology you're referring to?
No, the
How do you
opposite.
see that?
No, the opposite. The over 50s I'm thinking about are more technically hip than the under 20s. Oh, sorry, the under 30s.
Really?
Absolutely. I mean, they're people that have been in, they're teachers in one case. She's involved in professional services in the medical area. She's an ongoing client. There's people that have been in the music industry who are applying their learning about copyright now to graphene technology, which you may not have heard of, but it may in fact be as important as electricity. These people are 70, 65, and the thing is they've worked with technology like you and I have for 30 years, and the point about it is their attitude as to what they can extract from a lawyer. That's what's the difference.
Can I ask a follow-on question, and the chairman can rule me out of order if it's not really related to today, but I'm curious then about your costing methodologies and how the clients see that, because there's obviously significant startup costs in relation to a lot of this technology, and then you can give them an answer in less than 1 6-minute unit perhaps. So how do you balance that?
With the precedent management, costing becomes much more easy, because you have so many templates. You have short versions of things, long versions, biased towards one side, biased towards the other. So if you are given the opportunity to get proper instructions, you can laser beam down to a document relatively quickly and then work out costing and go, okay, it's going to cost you 2,000, 3,000, 5,000. With the older client who wants to actually get involved in what I called business model innovation, they don't even ask you about the cost. They'll go, what do I need to do here? And they know that they're just talking to you. They're not paranoid about, oh, what's this costing me, Noric? And so you then turn and say, look, I don't know enough. When I know enough, I'll give you a costing. So what happens there is, I'm surprised myself in those situations. So you end up, for example, doing a document that costs $12,000. You would never have thought it would cost $12,000. If you were asked in day one, you would have said, oh, $3,000, $2,000. Or you end up yourself doing a document that frankly might cost $30,000, but you charge $12,000 because that client is now so ingrained in your thinking and their thinking that they'll come back for more, and they do. So it's that old style lawyering that was relationship based that I'm having myself with the over 50, that regrettably I'm not having as much with the younger age people. Having said that, there are exceptions.